We're back on it's unprecedented times, unprecedented oral arguments of the United States Supreme Court, unprecedented group of unethical Supreme Court justices. That's why Dina, Dahl, and I named the show Unprecedented. We're following the United States Supreme Court closely. What happens inside the courtroom, sometimes what happens outside the courtroom is even more important. We do it all here, one place, exclusively on Legal AF. Take a minute, look for the blue button. It looks like my pop filter, and hit the free subscribe to help us build this pro-democracy channel in collaboration with the Midas Touch Network. Every week, we took a little break for Thanksgiving, but usually every week, Dina, Sayegh, Dahl, Michael Popok, I'm bringing it to you at the intersection of law, politics, the United States Supreme Court. Do we don't blow smoke or sunshine? And we've got there's no other way to put it. We had a disturbing oral argument. We sort of predicted it. You and I did a midweek edition of Legal AF on the Midas Touch Network, anticipating it. There were a lot of historic things that happened at the Skirmety oral argument about whether the puberty blocking treatment that youth and adolescents that identify as transgender used in order to align who they believe they are and want to be in terms of gender with their bodies. 23 states don't allow adolescents or anybody to do that, certainly not adolescents. And the question was, is there a constitutional right of privacy or equal protection that allows a parent and child to make this fundamental decision about their sexuality and not have to worry about what state they live in or what their neighbor thinks or feels? I mean, that is what the United States Supreme Court, that's what the Constitution is supposed to be for. When you're banging on the door for sanctuary because there's a mob on your heels with pitchforks and a torch about something about you, and they want to tear you from limb to limb or deny you your rights, that sanctuary door is supposed to be opened by the United States Supreme Court and protect you. They're not supposed to let the wolves take a vote as to whether you're going to live or die. Or in the case of sexuality, that is a life or death decision for most people. That is not the way this United States Supreme Court and its MAGA right wing sees things. They believe that they are 9, for their view, 6 justices that matter. And when they want to decide who lives or dies under the Constitution, they just make a decision that we can't do that. It has to be left to the states, knowing that the states are divided and the states are not going to, in a moment of heated rhetoric or a heated time that we may be in, may not protect somebody's sexuality, identity, privacy, reproductive rights, whatever. But that seems to be their take on it. Now, we're going to talk about the Skirmety case and the other historic aspect of it, which is that Chase Strangio, the first trans lawyer to ever appear before the United States Supreme Court, argued. He has a leadership position at the ACLU, the American Civil Liberties Union. He's in a unique position to defend transgender rights, but he got into a debate with some of the right-wingers that I want you to outline for our audience, including Alito and Kavanaugh, and all the while, with like a Cheshire cat, no grin, was Neil Gorsuch, who didn't say a darn thing during the oral argument when it probably would have mattered. Why don't you take the audience through Skirmety, and then at the end, we'll talk about, speaking of lack of ethics and conviction at the United States Supreme Court, we got another leak. This is the leakiest Supreme Court I've ever seen. We got another leak about the ethics code that they passed under protest, apparently, and the right-wingers taking a certain position about it, and of course the moderates taking a wholly different position about it. How shocking. But let's kick it off with Skirmety, named after the Attorney General for Tennessee, and a very, very important case to our nation's youth. I saw an estimate. There is over 110,000 transgender youth that are denied gender-affirming care. That's a lot of people, and I'm sure there's even more than that. Why don't you kick it off and talk about what happened at oral argument? Briefing is done. This is the oral argument where the 9 get to ask questions and the advocates are up there advocating. The Biden administration is there on behalf of the Solicitor General's office, right? We're in a weird period of time because this is pre-Trump's arrival and his Solicitor General. What happened in the court?
So this was a hugely significant oral argument, not just for transgender care, although that is huge, obviously, but the positions that the right-wing justices took may end up having huge ramifications for protecting laws that discriminate based on sex, frankly. So really a wide-reaching oral argument, and why it's so important for us and why we're taking the time to discuss it today. For everybody also, just to kind of point out, we get a lot of information from the oral arguments because based on their questions, we get a preview, basically what they're thinking, but we're not going to know until June how this ultimately comes out. But so basically quick recap, in Tennessee, they banned non-surgical gender affirming treatments based specifically on sex. So if you are a boy in Tennessee and you want to, and this was an example used by Justice Ketanji Brown Jackson through the oral argument, if you want to have your voice be deeper, you're allowed to under the law. But if you are a girl who want to have your voice be deeper, you're not. So specifically these, as you say, the hormone blockers and also hormone enhancers are both allowed or disallowed specifically based on whether or not you are a boy or a girl. And also part of the statute says specifically, like they literally say, we want, these children, or we want people to be like affirming their gender of birth, kind of like celebrating their gender of birth. They just put it right out there that that's their purpose. They're not even trying to hide it. So the argument from the Solicitor General is this is a clear, this is a sex-based law, right? Like you can get this treatment if you're a boy, but not if you're a girl, and vice versa. And so it should have heightened scrutiny, which is an intermediate scrutiny. And right without that, if it's just a law that's not infringing based on sex or race or anything else, you would just have a rational basis. Essentially, Tennessee would just have to have like a rational reason for it, which is very mundane. Pretty much anything is going to pass rational basis. And their argument isn't really asking for the Supreme Court to like overturn that law. That's not what they're asking. What they're asking for is saying, hey, this is sex-based discrimination. And so the lower courts need to apply a heightened scrutiny, and they have to show evidence, the importance of the law, and be able to kind of like hash out whether or not this law can pass that heightened scrutiny. That's really what they were asking for, the Biden administration, which honestly, like so reasonable. And the point they made that point so clearly, that justices, Ketanji Brown Jackson, the liberal justices, this is not something that is debatable, really. But of course, as we know, Justice Alito, Justice Thomas, wanted to bring in European research to try to say that, somehow, the states are justified with this. They have this obsession with Europe. We've talked before about how Justice Alito, hung out with the German princess. So anyway, they decide the European medical research has to do with this. But Justice Kavanaugh's questioning was so disturbing. His questions were very similar to Dobbs. He said in the statement, I was frankly, so disturbed. It was isn't this just a medical or policy question? And the Constitution has no, shouldn't apply or have no purpose in this, right? And that's really what he said in Dobbs too, was shouldn't this just be left to the state? I don't know if I've seen a Supreme Court justice want to neuter the Constitution so much when it comes to people's individual rights as Justice Kavanaugh. And frankly, he is the perfect explanation. We talk a lot about why diversity is so important. And he's the perfect example of why that is, because he has never, had his own rights tried to be stripped away. And so for him, he thinks, what's the point? Why does the Constitution need to help somebody, right? Because, it's a white man born into, privilege in America doesn't often have their rights stripped away by law. But Justice Ketanji Brown Jackson has had, maybe not that personal experience, but at least that life experience. And she brings up over and over the comparison to Loving. Now in Loving, as we know, they tried to outlaw interracial marriage, and they used a very similar justification as this Tennessee law did, try to bring in science and all of that. And as we know, the Supreme Court overturned it. But frankly, she was, I thought, as fired up as I had ever heard her, really disturbed. She was like, I'm very worried about where these arguments are going, because based on what Kavanaugh and Alito and Thomas were saying, it was almost if this current makeup of the Supreme Court would have allowed Loving to stand, would have actually allowed the ban of interracial marriage. That's how fringe their arguments were. And I thought that juxtaposition between Kavanaugh of the Constitution, we don't need the Constitution when it deals with this, right? And then her being like, no, we do, because we, otherwise rights of my community have been affected. And I just thought that was a perfect example of why you need diversity on a court, because frankly, Justice Kavanaugh just doesn't get it. Justice Sotomayor did the same thing. The Tennessee lawyer tried to say, this should just be democracy, right? If the transgender community want to be protected, it should be democracy. And she, again, having also this life experience of a diversity, was like, well, frankly, democracy doesn't protect the 1% of this country. I'm pushing back on that. So her and Justice Ketanji Brown Jackson, I thought, were just, more fired up than I'd heard them in a long time, really trying to kind of sound the alarm, frankly, on where this court is going, not just with transgender medical treatment, but this idea that they were so willing to have a very obvious sex-based classification law stand on the books.
Yeah. This right-wing Supreme Court doesn't just want fetuses to live, even if their mothers don't want to within a reasonable period of time. They want them, once born, to live the way this 9 or 6 person panel wants them to live. You had Kavanaugh up in arms about this is the red herring that they used during the election. Women, transgender women in female sports. I don't want my daughter playing against a guy. First of all, this is about puberty blocking. This is about gender. This isn't about men electing to become women, as is their privacy right and should be their right in this country or any country. This is about children pre-puberty who want to not go through puberty and become the next thing. They want to at that moment. And so it's just a red herring, distractive argument but it had such a visceral power. It just grips the American mind and it makes them go crazy about this. Whole election was about either the economy or transgender women's sports. And so you had Kavanaugh standing up for something that doesn't even exist, which is men play, that mean meme that Donald Trump used during the campaign of the guy, obviously guy with hairy arms and lipstick playing against a girls squad. In fact, the day of Skirmetti, the Ladies Professional Golf Organization, the LPGA, issued a rule that unless you went through pre-puberty blocking, you're not going to be able to play as a woman in the Ladies Professional Golf Association. So that means that. So I thought, well, that's a reason to allow it, right? That we need to allow them, but instead you've got the Catholic monarchist in Sam Alito, who loves wearing ermine and red robes with giant medallions, trying to restore monarchies all around the world, and as Catholic ones at that, weighing in about Swedish studies about people who have had second thoughts about having had gender-affirming healthcare at some point in their life. And that's what they latch onto with Alito and Thomas. What about the few people? And it's like it's literally like one or two, that they've thought better of it. Is it really an immutable characteristic, transgender, or is it something that they can change? Why are we protecting it by a constitution? It's what you said. Because there's certain principles you can't put up to democracy. You can't put up to a majority vote, because if you put it up to a majority vote, we may reinstall slavery.
Right.
We may send Jews out of certain states. We may, right? We may have
Right.
women not be able to vote or own land
Mm-hmm.
today. Okay.
Mm-hmm.
And so that's why you don't leave it. And the Constitution says that the Supreme Court and the Constitution are supposed to protect the disenfranchised, the disadvantaged, those who are the target of the angry mob and the mob mentality, and the prejudice and bias that comes from that type of anger. The Japanese American who was put into a concentration camp during World War II because we were so fearful after the bombing of Pearl Harbor, right? The
Yeah.
Jews who were denied the ability, and Irish and others, to own property, to stay in hotels and motels because of the fears about, the anti-Semitic strain that's in American culture. The Constitution is not supposed to allow that to happen and just say, leave it to the states. That's like saying, leave it to the wolves to decide what's going to happen to the prey.
Mm-hmm.
And it's disgusting to see it. For John Roberts to look Chase Strangio in the eye, one of the advocates there, who happens to be transgender and a father of a 12-year-old, and tell that person, it's medical. We don't like medical and almost babies. That sounds like Dobbs. No. That's not for the role of the nine of us. That
Mm-hmm.
we got out of that business with Dobbs. He didn't quite say that, but that's what he was implying. No. We don't do that. We don't do science anymore. We don't do medicine. We leave it to the legislatures to do that. Let the elected officials. And if you happen to live on the wrong side of the state border, then you don't get to be the person that you always wanted. And that's just tough shit. I mean, that's what I just heard during the
Mm-hmm.
oral argument. And it looked like the moderates, the free thinking moderates there, even though there's caucuses and they talk about some of this stuff, even they were shocked by the way this was playing out.
Mm-hmm.
And between the Swedish data, which is often a lot of times you can find a study to say anything, but that was in an amicus brief, so it was spoon fed to Alito. Oh, what about those two people that regretted the puberty blocker? Okay, what about the 100,000 that wanted to live a life and not commit suicide because
Yeah.
because of their gender? When they look in the mirror and they see the wrong person. What about that? Why
Mm-hmm.
don't you go through life like that? So
Mm-hmm.
I think it caught the Sotomayor and Kagan and Ketanji Brown Jackson a little bit flat-footed, but they should have saw it coming, because once Dobbs got on the books and they ripped away the constitutional right for a woman to choose, in other words, not finding in the Constitution enshrined there anything that protects reproductive rights. This is just the next logical step. They don't do science. They don't do math when it relates to reproductive. So if you have science, math, times reproductive health, times
Mm-hmm.
sexuality, this Supreme Court is not going to protect you. At least the six of the Supreme Court are not going to.
Mm-hmm. It was so disturbing in this day and age, hearing these justices or not all of the justices, like I'm talking just about the right-wing ones, so ignorant, frankly, about what the transgender community is going through. Like, to your point, like, they are trying to save their children's lives. Like, I know people whose children have gone through this, and it is incredibly hard. And for them to take away a parent's and a child's choice with their doctor is frankly disgusting in this day and age. And Justice Roberts knew he could not say that this was not a sex-based classification. So he put this carve out to say, well, maybe only with medical policy, we will not have this heightened scrutiny. We will in other situations, but not medical policy, because he cannot just look those people in the eye and say that they deserve the heightened scrutiny. I mean, honestly, the White House Solicitor General was so reasonable. She was like, we're fine with the West Virginia law, which requires multiple doctors to talk about the severity of what the child is going through. They are not asking for a lot. And for the Chief Justice of the Supreme Court to be so minimizing of what the transgender community has gone through, and to have a carve out with medicine. I mean, the precedent, we're talking about unprecedented, the precedent that will happen if he gets his way is scary. So basically, what's to say that a law can't ban women from getting contraception, right? I mean, sex-based classification, but we have a carve out when it deals with medical policy. We are getting into really, really dangerous territory. And that's kind of what I said in the front. Like, this is really bad for the transgender community. It's really bad, I think, for women, because let's be frank, most laws try to regulate women's healthcare choices and not men. But that's where they're going. That's where Chief Justice Roberts is going. Rather than just say, hey, let's give them intermediate scrutiny. We're not even talking about like strict scrutiny here. The most reasonable thing, he wants to have a carve out that other laws can regulate specifically women health and not have scrutiny. I mean, it's mind-boggling. And that's, I think, why we saw the liberal justices, just like you said, not only be flat-footed, because the depravity of where they were going is shocking, even when we know this is where they want to go.
This is all performative anyway, because we're in this interstitial moment between administrations. So you have Elizabeth Proliger, who's the Solicitor General, arguing for the Biden administration position, a reasonable one. But that is not the position of the incoming Solicitor General, Donald Trump's former criminal defense lawyer, John Sauer. And John Sauer is going to submit a paper while this is sub judice, meaning under advisement by the Supreme Court. It's going to take them several months. We may not get this ruling. They're certainly going to wait past January. So they're going to get a new filing. And it's going to say everything that she just said, Elizabeth, Solicitor General for Biden, is wrong, and we disagree with. And here is our new position. We're now the elected officials. The American people spoke, and they put Donald Trump in office, and his Solicitor General comes along with. And here's our new position. You should not hesitate to affirm the ban on transgender puberty blocking in Tennessee and every other state. And here's all the reasons why. You were right on target during the oral argument, and we totally agree. Forget our prior briefs, the Office of the Solicitor General. They're gone. I wrote that in a social media post, and somebody said, I don't know if they were challenging me, show me one example where an incoming Solicitor General wrote a paper like that. Every incoming Solicitor General, when the position previously taken and the case has not yet been decided, if it is the administration's policy that's different from what was taken, they file a paper that say we are withdrawing our opposition, or we're joining, or we're there. It happens all the time. A lot of people think, show me one example. I'll show you every example. Every incoming administration, including the Biden administration, took positions that were different than the Trump administration, and in pending cases let the Supreme Court know that. So that will happen. What were you going to say about the silent Kavanaugh, the Mona Lisa Kavanaugh, and Amy Coney Barrett?
Yeah, so it's interesting. The one justice who didn't speak at all was Justice Gorsuch, and normally he likes to make his little snide comments. So that's unusual for him. But the reason why is he was the one that wrote the Bostock opinion in 2020, which said that under Title VII, employers could not discriminate based on sexual orientation and transgender. That's, I think, one of the only Supreme Court opinions.
Which Roberts joined.
Yeah, right, exactly.
4 years ago.
Yeah, not that long ago. And I think that's one place, you can correct me if I think that's the only place the Supreme Court even addressed transgender rights. So, you could say he's got the landmark transgender opinion as to date. So for him not to have said anything is very interesting, because he obviously didn't want to play his hand. I think that's why he kept quiet. Will he stick to what the difference, right? Because this was addressed in oral argument. They're like, the difference is you were dealing with the statute, Title VII, versus whether or not there's an equal protection right. But I thought that the Solicitor General, addressed that well. The concept is there, though. The concept is there, and he was on the side of protecting transgender rights and sexual orientation rights. So they just
don't want to make any new ones.
Yeah, they don't.
I hate to be rude, but they just don't. They're going to protect the existing transgender community in a limited way in Title VII. This is how he's going to reconcile it, but they don't want to make any new ones.
But I thought the Solicitor General was good at that, because she kept on saying, we're not looking for anything new. We just want to heighten scrutiny. But actually, I thought that was the interesting part about Justice Amy Coney Barrett. She's the other person that we always like to watch for. And her questions, she seemed most interested in whether or not being transgender can be a suspect class. She seemed most interested in whether or not actually protecting being transgender. So
that's the immutability issue.
And the Solicitor General didn't want to go that far. She wasn't asking them to go that far, but she seemed really, I wasn't sure which way she was going.
Class or protected class?
She said suspect class. That was, but I think she meant a protected class, because it's been discriminated against in a suspect area. I thought it's possible, like I could see her writing an opinion, maybe be concurring, but saying, that this should become a protected class. She also brought up a few times how will the parents still have their own due process rights? So I can also see kind of maybe writing a concurring opinion, thinking the parents still have a due process claim in this. She cared about the parental rights, but she didn't really ask any questions other than, frankly, whether or not the transgender community should be protected and parental rights. Will that help in this situation? I don't know, but
this ban is getting upheld.
Yeah.
This ban is, I don't want to blow smoke here, sunshine. This ban is getting upheld. There's not 5 votes to strike it down. Chase Strangio, by the way, rock star. I can't wait to see him perform in other oral arguments and settings. He runs the LGBTQ plus and women's rights department or division of the American Civil Liberties Union. And I'll just do a plug for them. We're often plugging us. And Legal AF, the Midas Touch Network, fund the ACLU, donate to the ACLU. They're going to be on the front lines, tip of the spear, filing lawsuits about the Trump administration and its worst instincts. And Elon Musk, who likes to, I don't know what he likes to do, but he sits around in social media postings, writing, delete this administrative agency that helps American people and protects American people. Delete this one. And yesterday he wrote, defund the ACLU. Well, first of all, the government doesn't fund the ACLU. That's an independent, nonpartisan entity that's been around for a long time that takes personal donations to fund themselves. So there's nothing to defund. They're not within the grips of his Department of Government Efficiency. And he didn't like the fact of the position they were taking in the transgender case, which is, of course, ironic because one of his 10 children is transgender. She's outed. I'm not saying anything that is not is private. But, and statistically, I'm not surprised he has 10 children. So one being transgender does not shock me, given the statistics. But, he's just a disgusting human being. And that's where we're at. We've got an ethics thing to talk about, too.
Yeah,
right?
Real fast about Elon Musk. I mean, I think his reference was to the fact that House bill 9495 will. It seemed there were frankly way too many Democrats who voted for it this time around, and it's going to not go away. And if it passes,
what is it? Tell our audience what that is.
Okay, yes. So what it is it will allow the Trump administration, to declassify, like to change their tax exempt status of any charity. They could say that a charity is a terrorist organization with zero evidence. Like the bill has no due process. They don't have to submit any evidence. And so I think when Elon Musk says he plans on defunding ACLU, that's how he means.
Yeah, you're probably right about that. That was an idiot move by the Democrats who thought they were doing something bipartisan when they didn't think Trump was going to win or return to the White House. They thought, the Democrats will use this properly. And they didn't anticipate effing Trump coming back. Let's talk about the ethics leak again. So just to bring everybody up to speed, infamously, the Supreme Court has always taken the position that they're not subject to any ethics code, even though every court below them is. And instead, you get things like the tautology that John Roberts gives, which is it's basically that they believe they're infallible. We're ethical because we say whatever we do is ethical. Like, what are you talking about? We've been reporting for almost 4 years now about the millions of dollars that Clarence Thomas lined his pockets with and didn't disclose from Federalist right-wing donors, including, glitzy, junkets abroad, overseas and yachts and private planes. Same thing for Alito, same thing for Gorsuch, same thing in a way for Roberts, where his wife makes a living placing being a headhunter for major law firms that have business in front of the court. None of it disclosed. And so all we wanted was a simple ethics code. And finally, only because the Sam Alito flag incident, where his wife was flying the flag of insurrection in front of their house during this time period and other things, they finally think, we got to get the masses, we got to get the public off our ass in Midas Touch and Legal AF. We got to pass an ethics code. But they did it for completely different reasons and with completely different approaches, the right wing and the moderate wing, about what the purpose of it is. And it's all leaked out. What have you heard?
Yeah. I mean, so basically it's not surprising, as you said, the kind of compromise, the internal conversations was not to have it be enforceable. And it was the right wing that we talk about all the time, the Alitos, the Thomases, that wanted it that way. They didn't, I think, want any disclosures, but they didn't for sure want it to be enforceable. And so that's what we ended up getting, is this kind of compromise where they voluntarily, disclose things now, which is frankly how we found out about Justice Alito, getting those not trips, but it was like the dinners, et cetera, with that German white supremacist princess that we talked about in a different show, was from that kind of like voluntary disclosure. This is my theory on the Supreme Court, why they gave Trump so much power with this immunity decision and kind of were willing to have him be above the law, is because they want to be above the law. And now they have like a precedent on the books that I think they're going to point to. I think we're going to get to a point, which maybe not for many years, where there's going to be a congressional law that is passed that tries to kind of rein in the Supreme Court and the ethics. And they're going to point to that decision as these are co-equal branches of government. And if the president can't have their actions reviewed by the criminal justice system, we certainly can't have our actions reviewed by Congress. I think they want there to be this like untouchable power, not only in the presidency, but themselves. I mean, that's why Chief Justice Roberts has never come down to any of the committee hearings, even though he's been asked many times to talk about it, because he doesn't think that he has any, he doesn't think that he should be answer to anybody. And, the thing about the Supreme Court is their own power has really come from their own interpretation, right? I mean, our laws, our Constitution, a lot of it has developed over the years. And the Supreme Court was the one who decided for themselves, what their review process and what their power was. And I think that's going to happen again. And so we are in that stage of them wanting to, I think, give the president more power because they want to give themselves more power. I don't know, maybe we're lucky that they even agreed to a voluntary disclosure, but it's really disappointing when you have federal judges who won't even like take concert tickets or, dinners because they want to appear impartial, because that is the purpose of a judge, is for people in this country to go before the judge and feel like they're going to get fair treatment. And that's what somebody should expect from the highest court in the land. And I've said again, like, if you're going to take that much power and be willing to be a Supreme Court justice, there's some, downsides to it. And maybe a downside is that you don't take those $1 million lavish trips from people who are going to have business in front of the court.
Well, you're exactly right. Right. I mean, first of all, that's why it's always the hypocrisy of it all. It's always the irony of it all, which of course is lost in the Supreme Court. They always like to talk about the textual. They're textualists. They're originalists. If they don't see it in the literal words, the expressed words of the Constitution, then for them it doesn't exist. They don't believe in the penumbra of rights that emanates from the interstitial moments between the rights, and that creates an umbrella of rights that you and I learned about in law school. But the irony of it all is that the United States Supreme Court and what it does for a living isn't defined in the document that they are charged with with resolving. They're nowhere in the United States in the Constitution does it say that the Supreme Court does what it currently does, which is interpret the law of the land, federal and the United States Constitution. That's only because in 1807, John Marshall, the first Chief Justice, said that's what it was for. So it's just a case. Marbury versus Madison. That's why there's 2 giant statues of John Marshall down at the United States Supreme Court when you go and visit. This ethics code thing is just utter and complete bullshit. The right wing agreed to it because they never had any intention of complying with it. That's what the leak just told us. The moderates said, of course we need an ethics code. If we're not doing anything wrong, what's wrong with being bound by an ethics code? Every lawyer before us is bound by an ethics code. Every judge that we supervise is bound by an ethics code. Why would we be above the law? And that's why Roberts and all were always bristling with Congress trying to impose, in the Senate, trying to impose ethical obligations. They always say, we'll accept it, but you really don't have any power to tell us what to do because there's a separation of powers issue. And that would violate the separation of powers. So you can't tell me what to do. We can adopt it for ourselves. So, all right, we'll do gift disclosure, but we really don't want to. And you can't do anything about it. Like if we F it up, you can't complain about it. There's nowhere to complain to. Put it in the circular file. And that's how they approached, the Alito, Thomas, Gorsuch, Kavanaugh, Roberts. That's how they approached the ethics code. They did it to appease the moderates on their bench, but they had no intention to giving it any teeth, any enforceability, and there's no penalty if you violate it. So, like if a judge violates the judicial ethics code, the canons of judicial conduct, they can get severely reprimanded, sanctioned, removed from the bench, impeached. Well, they don't want that. This is too good of a gig. They don't want to give it up. So they're not going to. And so, it's interesting, these leaks that are coming out. I thought the most interesting thing about the New York Times article about it is how careful they were to try to avoid the leak. They didn't want to have happen what happened with the Dobbs decision 2.5 years ago, where a draft of it got left somewhere, I don't know, in a printer, and it got emailed out to the public about the draft decision to rip away a woman's right to choose. They weren't going to let that happen again. So instead of using email, they were scurrying the hallways with their clerks with like hard copies of the draft in revision until they got the ethics code finalized. They were that worried about the leak. Came out anyway. The thing let me just warn everybody. The thing that you don't want to get out is definitely getting out. It may not be the second, but it will happen because between social media, organizations like the Midas Touch Network, Legal AF, we are going to find it. You're most, and if it's a disqualifying thing, that you shouldn't be in the position that you've been put in or that you've been proposed for, we will find it. Look what's happening with the vacuum that Donald Trump tried to create around all of his cabinet picks of information. No information. Well, nature abhors a vacuum, right? Nature, negative space we don't like. So we'll fill it with our own reporting, our own investigation, our own stories. People will come forward because they feel like these people aren't being honest, like the Gates accusers, the Hegseth accusers. Soon, when the wheel spins and lands on RFK Jr., we'll hear all of those come forward, like the nanny, and the rest. And so, if you leave it to us as a people, and you give us enough time, we will get to the bottom of it. So whether you think having an ethics code as a Supreme Court is right, wrong, or indifferent, when you violate what we see as norms and morals and ethics that we hold our highest people to, including the lifetime appointed Supreme Court, whether it's ProPublica or whether it's court accountability action here on our particular network, or it's Midas Touch or Legal AF, we will find it and we will expose it. So you should adopt an ethics code and you should live by it and you should have penalties for it if somebody violates it. Because otherwise, this is why I think it's not down to single digits, but it's getting pretty close. 12% of America, 15% of America has any confidence in the integrity of the United States Supreme Court. I've never seen those numbers in my lifetime. I mean, Congress has always been sort of like, used car salesman level. Sorry, used car salesman. But the Supreme Court, And this is the legacy of John Roberts and this right-wing Supreme Court. They're going to shove these rules down our throat and up women's reproductive organs, but they're not going to, right? But they're not going to be, they're not going to be honored in our country.
Yeah, I know. I mean, as a city commissioner, I have an annual disclosure form I have to fill out that is enforceable. And it came about because there was corruption in politics, in government, right? And this was a way of people over the years trying to ensure the public that the public isn't, a public servant isn't selling their interests out for the highest bidder. As a lowly city commissioner, if we have such a public interest that I be ethical, like, of course we have that interest in the Supreme Court. And the more power you have, the greater the responsibility, not less of the responsibility. And Chief Justice Roberts, he wants to protect the power of the court. That's why he doesn't want this, right? Essentially, he sees himself as like an institutionalist. But to your point, like, you don't protect the institution by protecting the corruption. It's not giving your power away. It's protecting your power. I don't know if he's going to see that anytime soon. But if he doesn't, that percentage of people having faith in the Supreme Court is just going to keep going down.
Agreed. Ideal way to end our current episode of Unprecedented. Dina Sayegh joining me as a co-anchor here every week on Legal AF. Take a moment. If you like the show, leave a comment. If you really like the show, hit the subscribe button. Our goal is 500,000 by Jan 1. I think we're going to make it. I hope, but only with your help. Only with your help. There's different ways to support what's happening here. That's one way. There's a Patreon. Patreon.com/legalaf for all things legal AF as well. Dina Sayegh does hot takes regularly on the Midas Touch Network. She's over here doing hot takes. So am I. And these are the different ways that you can support the network, our sponsors, our channel, and the like. But it starts and ends with you. Otherwise, it's just me. And I mean, I really like Dina Dahl as a person. But and I probably have a Zoom call with you once a week to do this anyway.
Right.
I mean, but it definitely, we need to signal to the algorithmic gods out there that this channel is important to you. And being here with us is the first step, and then the other ways that I've outlined. So until our next Unprecedented next week, this is Dina Sayegh and Michael Popok signing off. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.